Hey, everybody. Welcome. Happy Saturday. Happy Memorial Day. We have so much to talk about. So we're going to, I always just launch into this like we're all old friends. And I forget that we've got new subscribers and I should introduce myself. So my name is Lori Hellis and I'm a retired criminal attorney. And I'm writing a book about the Vallow and Daybell case. I'm deep into it now that the trial's over, and but we like to go live and talk about all things true crime. So let's dive into it. A couple things we have today to talk about are Lori Vallow and also Brian Kohberger. So let's start out with the Vallow trial. For those of you who are just joining, please like and subscribe. Our chat has gotten so overloaded that we've had to turn on the subscriber only option so that our chat moves a little slower. So please, if you haven't subscribed and would like to comment, you'll need to pop out and subscribe and come back. Also, I just like to always let everyone know at the top of the show that all of your donations, your super chats and your PayPal donations all go directly to our moderator. So thank you for your generosity to her. So we are going to talk a little bit today about Lori Vallow. Those who have been with me for a long time know that that has been the main case that I've been covering because I'm writing this book. I have just sent out Freedom of Information Act requests and they're starting to dribble back in. So I'm hoping I'm going to be able to really launch into the details that came out at trial once I have all those documents. In the meantime, I'm doing lots of background stuff having to do with the LDS Church. And I want you to know, here's just a few of the books that I have read, so you don't have to. You're welcome. Including one or two of Chad's. And trust me, you do not want to read those. So the trial is over. Lori is guilty. The judge orders a pre-sentence investigation, ships her back off to Madison County, where she is awaiting sentencing. And the judge has now set a sentencing date. And that sentencing date is July 31st. So that is the deadline that the person, the office doing the pre-sentencing investigation has to have their investigation finished and back to the judge so that he can consider anything in their report. So now we're waiting for pre-sentence investigation, and lo and behold, we have new pleadings from Jim Archibald and John Thomas. And those new pleadings are a motion for a new trial. Now, I know this got everybody all up in arms, but frankly, motions for new trial are part of the process. So once the trial was finished, it is very typical for the defense to file a motion for a new trial. And if there are any remotely possible basis for a new trial, they will file for it. So I have up on the screen over here, I always get that mixed up, the documents so that we can talk about them. So the first thing that the defense says is that the court misdirected the jury in a matter of law as it related to the jury instructions on conspiracy. So what Archibald and Thomas say is almost a little silly, but it's an argument. So what they say is that the original charging document said that Chad, Lori, and Alex and other co-conspirators, both known and unknown. Now, this is a very typical catch-all kind of a phrase that's used in pleadings to keep your options open. So if at some point it appears that you have yet another co-conspirator, you don't have to go back and amend your pleadings, which means it does not have to go back to the grand jury, because the prosecution does not want to have to reconvene the grand jury if they can avoid it. Now, you might recall that at one point they did reconvene the jury, but no new or superseding indictments came out as a result. So what they were doing, what the prosecution was doing, was saying, just in case we turn up somebody else who was a co-conspirator, we're going to plead that there were potentially additional co-conspirators, known and unknown. So what Archibald and Thomas say is, well, if you count Lori, Chad, Alex, and other known conspirator and another unknown conspirator, that's 5 people. Well, it's just silly, because the known or unknown is sort of in the alternative. So here we have him saying, well, there were at least 5 conspirators, and so the jury instructions only said 2. Well, the statute, the law says 2 or more. So what the jury instructions said was 2 or more people conspired to commit the crime. So that could be Lori and Chad, it could be Lori and Alex, it could be Lori or it could be all 3 of them. And just the same, it could be Chad and Alex, it could be Chad and Lori, it could be all 3 of them. And so what John Thomas and Jim Archibald are saying is that by allowing the and or language in the jury instruction, they undermined the defense, because the defense had been put on notice that the conspiracy involved at least 5 people. And that's just silly. It's silly reasoning. It's silly the way that he's trying to interpret it. And so I don't see that going anywhere. But remember that asking for a new trial is part of the process of getting your case to the appellate court. So they're not going to get to an appeal until they've exhausted all of their remedies at the trial court level. So that means that they have to ask the court for a new hearing and allege that there were things that were done wrong in the first hearing. Now, I think there were things that were done wrong in the first hearing, but none of them are actually in this motion, with the possible exception of some of the character evidence. So let's go on and talk about the next one. The next one says the court misdirected the jury in a matter of law as it related to the amended indictment. I think this is grounds for appeal. It was improper for the court to allow the prosecution to amend the indictment in the middle of trial. That's crazy. So let's talk a little bit about why it's crazy. The indictment is the document that puts the defendant on notice of what they've been charged with. So, and you can't bait and switch those things. You can't say, oh, I'm charging you with first-degree murder, and then when you get to trial say, oh, just kidding, actually it was a burglary. because the defense is on notice of the charges and they have prepared for a trial based on those charges, the defendant has come to defend him or herself based on the charges that they've been put on notice have been brought against them. So it's not fair to then switch the charges in midstream. Now, the question is whether or not this is a serious enough alteration in the indictment to trigger an appeal. So I think that if the Supreme Court is interpreting the law very strictly, they may say any alteration of the indictment causes them not to be put on notice of what the charges are in their defense. However, a less strict interpretation might say no harm, no foul. Here's the reason why. The court, the original indictment was for grand theft charge that included the intent to deprive the owner of the property. And they changed it to read intent to deceive the owner of the property. Now, it may seem like a minor change, and to some extent it is, but did it put the defense on notice of what the actual charge was going to be? So it's possible that the appeals court or the Supreme Court could say, well, it's a minor enough change that regardless, we think it was proven and no harm, no foul. I don't know what the appellate court's going to say about that particular issue. That will be an interesting one to watch. It is highly unlikely, it is highly unusual, for a judge to allow the prosecution to amend their charging document in the middle of trial. And I think that's pretty outrageous. I understand why the judge did it. He did not want to stop in the middle of this very high profile case, recall the grand jury in Fremont County, send everything back to Fremont County, recall the grand jury in Fremont County, and represent it to the grand jury. However, there could have been another alternative. Had the judge said, I'm not going to allow this amendment, the prosecution then would have had to decide whether or not they were going to drop the charge, the intent to deprive language of, and drop that charge, the theft charge. They made it more complicated because the theft and the murder charge are in the same count. And from the very beginning, the defense said, this is a bad strategy. The defense also asked for bill of particulars because they knew that the statute that the prosecution had cited was not the language of the statute in the indictment. So they used the language from one statute and miscited the other one, the actual numbered citation. So I think that is going to be a harder. I think it's going to be an issue for the appeals court, for the Supreme Court, and I think that it is a potential error on the part of the prosecution and the court. So the next thing is a juror interview revealed that the jury instructions were confusing and that he knew of evidence not submitted to the jury. This is another one that I think doesn't make a whole lot of sense. First of all, let's talk about the fact Nate Eaton interviewed juror number 8. And he gave an interview to Nate Eaton. He also later was interviewed on Good Morning America, I think. And he was very well-spoken, very supportive of the jury process, very supportive of his fellow jurors. And so as Nate was asking him questions, he said, having seen all the evidence, all of the thousands of hours spent, how would you describe the efforts of law enforcement? He said, they did a good job with what they had. I don't know that you can ever train for something like this. I think they did a good job with what they had. You questioned some things that happened. I'm sure there's a reason for it. You question had some things been done differently early on, would any of us be here? And Nate says, do you have an example of one of those things? And he says, we didn't consider this during our deliberations because it was clear to us, the instructions were clear. Arizona evidence and testimony is only for demonstrative purposes. Now, the juror uses the wrong term here. He's a juror. He's not a lawyer. He's not a judge. And so he uses the wrong term. He understood completely the jury instruction, which said that the issue of Charles's murder only went to the issue of motive and pattern and all of those things, that it couldn't be used to prove that Lori acted in conformance with her bad character. And so the juror was very clear that he knew, understood the jury instruction. He just called it the wrong thing. Demonstrative evidence, if you'll recall, during trial, several of the law enforcement folks put up summary evidence. So, for example, one of the officers who was involved in the cell phone data, in all the GPS data, put up a map. And on that map, he pinpointed the times and the locations of the calls. That was a demonstrative evidence. That was to sort of summarize a great deal of data into one place. One of the officers had a summary of the bank accounts and what went in and what came out of the bank accounts. That was to summarize voluminous documents. So a demonstrative evidence exhibit usually is one that summarizes voluminous information. So the juror got the term wrong. He understood what he was saying. What he was saying was that particular information coming out of Arizona was not to be used to determine whether or not Lori was guilty based on the fact that she committed a crime in a different state or that she had bad character. But it could be used to show motive and a pattern of behavior. So he understood that. He just got the term wrong. But Archibald and Thomas jumped on that. And they said, hold on, demonstrative evidence is not supposed to be, it is not what that was. So then they say, oh, and by the way, the body camera that Nate goes on to talk to him about the information that he's talking about. So he says, we were all very respectful of the rule, the directions that we were given. But now being removed from that, I think the police department in Phoenix had some significant red flags, and they should have been following up on maybe we're not here. And Nate says, do you mean after Charles was shot? The juror says before and after. Nate says before and after. Yes, you're right. Before he was shot with the body cam. And the juror nods his head affirmatively. So what Archibald and Thomas are suggesting is that the juror knew when he was deliberating about the body cam footage of Charles going to the police and saying, my wife needs help. I don't think there's anything in that exchange that indicates that that happened. First of all, the juror doesn't bring up the body cam footage. Nate does. Second, we didn't get this information from this particular juror, but we did get it from the other alternate juror, whose name is Tiffany, who spoke out about her experience. She said as soon as she got home, the first thing she did was watch the Netflix series and to watch Dateline and 48 Hours and all of the stuff that she hadn't seen about the case. And I'm sure that was the case with this juror as well. There is nothing in the interview that indicates that he saw anything prior to his deliberations. And so I think this one just fails. I mean, I suppose they can call the juror in and ask him, did you see that body cam footage before you deliberated? I'm sure that his answer is going to be that he didn't. So I don't believe that any of these arguments go very far. They certainly do not get a new trial. There's no basis in these arguments for Lori to get a new trial in the trial court. Not at this point. It is possible at some point a judge could rule, the Supreme Court could rule that she needs a new trial, but the trial court is not going to order her to have a new trial. So the other thing that happened this week has to do with Brian Kohberger. Now, we all know that Kohberger went to a grand jury. His case went to a grand jury, and the grand jury brought back an indictment. He was indicted. He was arraigned on the indictment. And he was he stood silent, which you might remember Lori Vallow did as well. We don't know what their legal theory was or their decision or their reasoning in deciding to do that. Some lawyers just do it as a matter of course. They just stand silent and let the judge enter the not guilty plea. So I don't think anything really deep can be read into him standing silent. But there was a rather interesting development later this week. And one of the things that was released was the information that an investigative grand jury had been convened in Pennsylvania. Now, for those of you who are familiar with the case, you recall that Brian Kohberger and his father drove cross country from his University of Washington residence to Pennsylvania for the holiday. His dad flew out here and drove back cross country with him to Pennsylvania. He was home for, we're not really quite sure how long, but he was under investigation, under surveillance pretty much the whole time from what we can tell. And he was arrested in his parents' home. So then there arose a kind of a cold case where a woman had disappeared. She had been missing for over a year. Her body was found recently, and it was in the area within about 30-minute drive of where Kohberger and his family live. So there was a lot of interest in whether or not it was possible Kohberger could have been involved in her death as well. Now, we know that once Kohberger was identified as a suspect in this case, that law enforcement everywhere he's been started looking for other cases, other potential cases that he might have been involved in. And so we don't know for certain why this investigative jury, a grand jury, was convened. An investigative grand jury is a little bit different than a standard grand jury. So let's talk a little bit about if you, these cases all run together sometimes, but they do have relevance. And I got to look up the name of this case because I don't want to get it wrong. If you happen to be watching the Travis Rudolph case, in that case, the police officers who took statements took sworn statements. So it varies from jurisdiction to jurisdiction whether police officers take sworn statements or not, whether the person who is giving their statement swears under penalty of perjury that they are telling the truth. So in that case, there were several instances where the defense came back and said, but didn't you say in your sworn statement X, Y, or Z? So in Idaho, police officers do not take sworn statements. So whatever statements they give the police are not given under penalty of perjury. But statements given to a grand jury are. So witnesses are sworn in, they are sworn in under penalty of perjury, and they are required to tell the truth. So we don't know why this grand jury was convened. We do know that law enforcement in Pennsylvania has said there is no evidence to link Brian Kohberger to the death of the other person in Pennsylvania, to the case in Pennsylvania. There is no reason to believe that Brian Kohberger is linked at all to that unsolved crime in Pennsylvania. However, that does not necessarily mean that investigative grand jury had anything to do with that unsolved murder. What we do know is that Brian Kohberger's parents were called in to an investigative grand jury where they gave sworn testimony. They were subpoenaed to that grand jury, and they attempted to have those subpoenas quashed. Quashed is the legal term for going to a judge and asking a judge to throw out the subpoena because whoever has issued the subpoena didn't have a right to subpoena you. So they filed motions to quash those subpoenas before the grand jury. People jumped to the conclusion that this grand jury had something to do with the unsolved murder in Pennsylvania because of the timing. But there's nothing that indicates that grand jury was convened to investigate that unsolved murder. It could very well be that they are investigating how Kohberger behaved when he got to Pennsylvania, whether any laws were broken by the family in harboring him. And so it's possible that this grand jury being convened has absolutely nothing to do with the unsolved murder. So at this point, I think law enforcement's intention was to get the Kohberger parents in front of the grand jury and have them give their sworn testimony so that they couldn't later go back and change their stories. Now, we don't know what those stories are because grand juries are secret. And it would only be in the instance that the grand jury later called the Kohberger parents in and asked them questions and they changed their stories, that the grand jury would be able to use that information to ferret out what the truth is. So I hope that explains that piece of it. Now, Kohberger was arraigned on his indictment, and the prosecution has 60 days to determine whether or not they are going to file for the death penalty. A trial has been set in October, and but at this point, thank you, Janet, for putting up the name of the woman who in Pennsylvania that was murdered. Her name is Dana Smithers. So at this point, trial is set, and he has not waived his right to a speedy trial. Now, we saw that play out with Lori Vallow. We don't know how it'll play out here. We also saw it play out with Chad Daybell, who did waive his right to a speedy trial. As I've said before, the common wisdom is that delay works on behalf of the defense. And so I would be surprised not to see him waive his speedy trial rights, particularly if the prosecution waits until the last minute to file their notice of intent to seek the death penalty. So that is a situation that we will have to wait and see. We still do not have a court date for Chad Daybell. And that's a little surprising. I know that, remember, the venue in his case was changed as well. So his case will take place in Ada County in Boise, which means that the court is having to arrange a court date with the Ada County Court. And you also saw that that was a real problem when they ended up having to delay Lori's hearing because of last minute determination whether she was still competent to proceed. So we don't have a court date yet for Chad. Chad's attorney, John Pryor, has asked for it to be set into next summer. I don't think the judge is going to buy that. I think that he's going to set Chad's case sometime within this year. But if he's going to do that, he needs to get it on the docket pretty soon in order for it to be able to go forward. So I expect that we're going to see it pretty soon, before the end of the year, I think. So, but I've been wrong before in this case, as have a lot of other pundits. So we'll wait to see what happens. But as it stands right now, Chad's trial will go forward. We've talked at length about whether or not I think that Chad will plead. And I think there's a 50-50 chance that Chad enters a plea. I think his counsel have seen all the evidence. I think that he's seen the theory of Lori's case. The theory of his case could be slightly different, but he's seen the way that the jury received that evidence. And I think he may determine that taking the death penalty off the table may be enough to get him to plead as well. We'll see. So that's about all the new stuff we have to talk about, but I'd love to have your questions, and I'd love to chat about what it is that is on your mind. Lori Newton, this is a good question. And I also had a question in my email, which I'll address as well. Do you think Boyce will give Lori a lesser sentence than life without parole? I don't think so. I don't believe, and part of the issue is the difference between determinate and indeterminate sentencing. So we in the two jurisdictions that Lori has charges, they have two different ways of approaching sentencing. In a state that has indeterminate sentencing, the judge will set the period of time before the person can ask for parole. The judge could say, you can't ask for parole for 25 years or whatever, or could say life without parole. I believe that Judge Boyce will say that she gets life without parole. In a determinate sentencing state like Arizona, the statute is very clear, and there is a sentencing matrix that determines what a person's sentence will be. And in a mandatory sentencing state, the judge doesn't have any discretion. So, for example, in Arizona, where Lori is charged with conspiracy to commit murder for murdering Charles. Now, she is not charged with murder. She is charged with conspiracy to commit murder. And in Arizona, those charges have different mandatory sentences. In Arizona, unlike Idaho, conspiracy does not carry the death penalty. The maximum sentence is life with 25 years before parole is allowed. And so that is the mandatory sentence that she will be sentenced to. The judge in Arizona will not have any discretion to say, well, I think maybe you should be eligible for parole in, say, 20 years or 12 years. The judge doesn't have that discretion in Arizona. So if Lori is convicted in Arizona, she will receive a sentence of life with 25 years before she is eligible for parole. That's different in Idaho, where indeterminate sentencing means that judges have more discretion when it comes to the length of time before the person can be eligible for parole. So in this case, where you have a presumed life sentence, the only question in the Idaho charges will be whether it's without parole or whether at some point she will be eligible for parole. Good question. There is a newsletter. It's in my archives. It's back a ways, probably a couple of years ago, that deals with the difference between determinate and indeterminate sentencing for anybody who's interested in that. Hi, Barty B. I thought that the defense had a team doing a mitigation investigation and report when the death penalty was still in play. Will that report also go to the judge for consideration? Good question. No, it does not. However, they will use the information that their mitigation specialist develops to support their position that Lori should get something less than life without parole. So the information, I'm sure, will be presented to the court, and the court will be asked to consider those things, such as her history growing up, her mental state, her educational background, all of those things. He'll be asked to consider those things. Well, that is if Jim Archibald presents them. He didn't do a great job of presenting much of a defense. So provided that they present that information to the court, it'll be presented to ask the court to mitigate the sentence. But the report itself will not be given to the court. That's a good question. Y'all are getting so smart. You're not asking questions about what's a grand jury. You're asking questions about the nuances of these cases, and that's impressive. That means we've been together a while. Hello, Janet. Question: do you think the prosecution held back any evidence that implicates Chad? I think the only thing we have not seen is Chad's cell phone data. Now, I think that it may implicate him more clearly. We have not seen information that may have been contained in Chad's phone, contents of some text messages. We have not seen probably all of Chad's phone data. Other than that, I'm not sure. I think that we certainly have seen the bulk of the evidence. I could be wrong. They could be holding something back, but I kind of doubt it. Hi, Mary Howard. Thank you, by the way, for your generous gift for our moderator. Did the prosecutor in BK case, in the Brian Kohberger case, do a grand jury so the defense can't question the witnesses? This is a good question. Now, if you remember, when we did Chad's preliminary hearing on the original tampering with evidence charges, the prosecution, the defense was allowed to question the prosecution's witnesses. Remember also that the standard is very low. It's really, the standard is it more probable than not that this defendant committed this crime? So it's not a really high standard to meet. I think that it is likely that the prosecutor didn't put this case to a preliminary hearing, as most cases in Idaho go to preliminary hearings, for a variety of reasons. First of all, they did not want a lot of the information that was contained in that would be presented to a preliminary hearing to be made public. There was a lot of information in Chad's trial that we heard for the first time at his preliminary hearing. So I think they didn't want that information to be out in the public because of issues with a jury pool. I also think that they wanted to be able to keep. I think that in part they wanted not for the defense to be able to question their witnesses. I think that was part of it. But I think the bigger part was that they didn't want all that information out in the public domain before they had to pick a jury. Hi, Sarah. Do you feel as though the law discriminates consciously or otherwise against men versus women? For example, Lori getting a lesser than Chad from the start. Do judges go easier on females in general? Yeah, they do. I think it's an inherent bias. I don't think that it's anything, it's an unconscious bias, I think sometimes. I think sometimes judges take into consideration when a woman appears before them that woman might be a single mother, she might have kids at home, she might be the sole support of her family. In general, I'm not talking specifically about Lori, but in general, when a woman appears in court. So I think there's always that bias. But I do think that if you look at, just overall look at the law, you can see that the bias. In the state of Idaho, there are 8 people on death row. 1 is a woman, and her crime was heinous. She burned her house down while her children were sleeping in it, and husband, I believe. So I think that I think the system in general goes easier on women than men. I think the prosecution is less likely to seek the death penalty to begin with for women. I think juries are less likely to impose it for women. And I think judges are go lighter on sentencing than for women than for men. Now, I also think that there are this perspective shifts a little bit too, because I also think that there are times that juries find women less credible than men. So I think that there are times that juries will believe a man when a jury won't believe a woman. So I think there are some very deep inherent biases in our system when it comes to men and women. That's a really good question. I will say I hope that the bias is shrinking as time goes on, and we're becoming less biased between men and women. But I'm definitely still there. Hey, Squeaky Wheel. If Chad was to file for divorce from Lori, would it help his case at all, even if just in the court of public opinion? I don't think so. I mean, maybe somebody would say, do you think there'd be a juror who'd say, oh, well, he's divorced her now, so he's not culpable? I just don't see it happening. If he were to file for divorce from her, I don't know that it would help his case at all. We don't know because we have not, as far as we know, I think we would have seen it in Lori's case had there been evidence of communication between Lori and Chad about Tammy and that she direct discussion that she had to die. There was a lot of suggestion and a lot of sort of beating around the bush, but there weren't any really direct texts, is she dead yet? So I think we would have seen that if it existed. I've always said that if the marital privilege was going to apply at all between Lori and Chad, it would be as to Tammy's death, because there is an exception in the Idaho code for communication between husbands and wives when it involves one or the other of the partner's children. So the only way they could have gotten a marital privilege exception would have been as applied to Tammy's death. That doesn't seem to be the case because I think we would have seen it in Lori's trial. I don't know if it helps the court of public opinion at all. I don't think anybody really cares whether they stay married or whether they're divorced. And I don't think that it would sway the jury into saying, oh, well, it's okay because he divorced her. Good question, though. Hi, Lee here. Question, do they have to offer Chad a deal? Nope, they don't. I think they will, because I don't think the prosecution wants to try this case twice. They didn't want to try this case twice to start out with. So I don't think they're going to want to try it twice. And I don't think, so I think they're going to offer him a deal and hope to heck that he takes it. So. Oh, thanks, Left Undone. I'm sorry that we didn't get to meet when we were all there, but we'll do it. I hope that we'll get to do it at CrimeCon. And thank you so much for all of the compliments about my lovely daughter. Mary Howard. I thought I saw somewhere that Pryor received $160,000 and $600,000 from the state for defending Chad. Even though he's not a public defender, how does that work? This is an interesting question, and I have recently sent the state of Idaho a Freedom of Information Act request wanting to know the cost of the defense costs for both Chad and Lori. So I'm hoping I'm going to get this information. In a lot of states, even if you are a retained defense attorney, you can get help with the expenses associated with the case. If the expenses are far beyond what an average person could afford. So it is possible that Pryor is getting help from the state for experts, for his DNA person, for retesting all the DNA, for all of those things. They may have authorized him to spend up to that amount on experts. They are not paying him as a public defender. If they were, he would have to meet the public defender qualifications. And I haven't seen anything in the rules that it will allow there to be an exception for a retained attorney whose client runs out of money. So, I mean, I suppose it's always possible that they could be funding Pryor, but I don't think so. I think it's more likely that they're funding experts and trial costs. Can you comment on the recent hearing in the Petito case? Oh, this is good. I had really meant to have a conversation about this. So thanks for inviting me to do that. Can I comment on the recent hearing in the Petito case, that letter and the mother's explanation and motions to dismiss? Sure. So let's remember, first of all, and I do want to say that if y'all are interested in this case, Emily D. Baker, who is a lawyer, has been following this case. She follows a lot more civil cases, and this is a civil case. So if you want to do a deep dive into the Petito case, you might want to look up Emily D. Baker. However, for a quick gloss over what's been going on, let's start with the fact that, of course, Gabby Petito and her boyfriend, Brian Laundrie, took off in her camper van on a cross-country trip. She was doing Instagram, van life Instagram, and they were on this extended trip of several months. There is adequate evidence, there's copious amounts of evidence that they had a troubled relationship, that there was domestic violence involved, and that thank you, Michelle, for putting up the link for Emily D. Baker. You're so quick. There was ample evidence that there was domestic violence going on between Gabby and Brian, that it was a difficult relationship. And somewhere out in, if I recall right, Wyoming, they split and went their separate ways. According to Brian, Brian showed up back at home in Florida with Gabby's van, but no Gabby. Gabby's parents were frantic, trying to find out where she was, and he wouldn't say, other than that he left her in Wyoming. So the Petitos believed that he had hurt Gabby. They believed that he was not telling the truth, telling them where she was. And the search went on for quite a while. During that time, Brian Laundrie was living at home with his family. They took off and went on a camping trip together. They spent a substantial amount of time together. It was it gave the appearance that they were trying to make themselves scarce. And then Brian disappeared. He disappeared. He was gone for some amount of time. It was during the winter when the water's very high in the swamp. And it wasn't until sometime later that his body was discovered and that he had taken his own life. They were able to find his notebooks, some journals that he had kept during the trip, and sort of a half-hearted confession that he had murdered Gabby. Gabby's body had been found by this time, and the Petitos were very angry with the Laundries because they felt that the Laundries had this information and didn't tell them. And so they felt that they knew where Gabby's body was, that they knew Gabby was dead, and that the Laundries had withheld that information from them. Now, there's no way for there to be a criminal prosecution because there's no the law enforcement has not brought criminal charges against the Laundrie parents for any kind of obstruction of justice or harboring a fugitive. And Brian Laundrie's dead. So the only recourse that the Petito family has at this point is a civil suit. So they have filed a wrongful death suit. Now, a wrongful death suit has the advantage of having a lower standard of proof. You don't have to prove beyond a reasonable doubt, which is like 99%. You have to prove, you only have to prove by 51% by a preponderance of the evidence. So it's easier to get to prove that. So where the interesting thing came in was after they filed this suit against the Laundries hired a lawyer who's based in New York, who started making statements about the case. And his statements about the case made him probably more involved in the case than he probably should have been. However, the Petitos went back and revised amended their petition to include the lawyer as having caused them emotional distress. And so there have been a couple of different hearings having to do with the lawyer and dismissing the lawyer out of the suit. Now, it's very typical in a civil suit for once the petitioner or the plaintiff to file, and for the respondent or the defendant to file a motion to dismiss and to say there's no basis for this suit. Even if you believe everything they said, there's no basis for the suit. So the two different motions, one was a motion to dismiss on behalf of the Laundries, and the judge denied that motion, but did take under advisement, as far as I know, the issue of whether or not the lawyer, there was a basis to hold the lawyer responsible for intentional infliction of emotional distress and wrongful death. So the other thing that happened was there was a discovery hearing, and at the heart of this discovery hearing was a letter. It's undated, but they've been able to place it sort of chronologically in the series of events, and but there's a dispute as to when this letter was written. The letter said, "Burn after reading." And the letter said, "You're my son. I'll always love you. I'd help you bury a body. I'd put a file in a cake. And she goes through a whole bunch of things that she would do for him. And if you need to bury a body, I'll bring the shovel. If you're in prison, I'll slip you a file." And I don't know, to be honest, if you take the letter as having been written after the Laundries should have known that Gabby was dead, then it takes on a pretty sinister tone. If you assume that the letter was written before that, then it sounds kind of like hyperbole. It sounds like a mom saying, "Oh, no matter what happens in my life, all yours, I'll always love you." And I, you're right. It was found with Brian's swamp notebook along with his confession. What we don't know is when she gave it to Brian and when Brian received it. So we don't really know. And that calls it into question. I certainly believe that the plaintiff was entitled to have it, and that okay, now somebody's saying it was found in his car. I'm not sure where the letter was found, but it was found among his personal property. And I'm not super up on this case. I did watch a couple of Emily D. Baker's lives on the hearing and on what had led up to the hearing, but I am not the expert in this case. So I guess my take on it is, if the letter was written and given to Brian after Gabby's death, it certainly takes on a more sinister complexion. If, on the other hand, it was a flippant, fun, like meme, we'll be friends forever, if it kind of you see those memes all the time. Oh, I'll help you bury the body kind of thing, which is how she explained it. She explained that that some of the things that she said were taken completely out of context because there were quotes from books they had read together, or they were takeoffs on books they'd read together. So I don't know how impactful that letter in particular is going to be. And I don't think that the lawyer is going to be, the judge is going to keep the lawyer in the suit. I think the lawyer gets dismissed out because in listening to what he said, I didn't find it to be particularly damaging or I mean, he said something kind of non-committal, like, we hope she's returned. Did he say dead or alive? Did he say we hope her body's returned? He didn't. He just said we hope she's returned to the people who love her. So definitely check out Emily D. Baker if you really want to take a deep dive into the Petito laundry case, because she has been on it from the very beginning. And she did an excellent job of covering Amber Heard and Johnny Depp. And that area is much more kind of her wheelhouse. So she covers a lot more of those sorts of entertainment cases. She does a lot of movie stars, and she's been talking a lot about Vanderpump Rules, which I have never seen, I have to admit, but I hear is pretty juicy. So for further information about the Gabby case, please do go check out Emily. Hi, Jory. This is my first time here, and it's alive. Lucky me. I saw you on Surviving the Survivor recently. Deeply insightful. Thanks. I tend to be a little less formal on my own channel than I do when I'm on with Joel and Carm or on with Joel. But I'm glad you're here. Welcome. I'm pleased that my appearances on Joel's channel on Surviving the Survivor have led folks to find me and to tune in. For those of you who might be new, we do, I always get that backwards. We do True Crime Quilt Guild. So these squares that you see up on the wall, I promise I'm going to get this quilt finished. And but these squares you see up on the wall are our quilt along, and it's something that you can join at any point, and very suitable for beginners. And I do have some instructional videos on my YouTube channel, so that's a lot of fun. And we talk about other cases besides Vallow. And now that Vallow Daybell is sort of on a hiatus until we find out what's going on with Chad, we'll probably be talking a lot about other cases as well. If you have cases that you are interested in, I am going to go back through my notes from our earlier True Crime Wednesday, our earlier evenings. And I am going to go back through those notes and look at and catch up on some of the cases we've talked about before. But right now, we're just going to sort of catch up on the ones that we've been following closely. So if you have cases that you would like me to take a look at, please drop them in the comments or drop me an email and let me know, and we'll take a look at them as well. There is a case that I am particularly interested in because I've been following this person on Twitter, and her name is Lauren Malloy, and she has been, and I want to pull it up so that I don't get any of it wrong. Lauren has been looking into Lauren Lee Malloy, Malloy is her name. And she has been looking into the death of her mother and her mother's unsolved murder from 30 years ago. Her mother's name was Lori, spelled like the good Lori. And she has been continuing to keep her mother's case in the forefront of people's minds. And she's hoping that her mother's, that the officials are going to approve an exhumation so that she can have a new autopsy done on her mother's remains. She was a young child at the time that her mother died, and she has been searching for answers on this cold case for 30 years. So it's a fascinating case, and I would definitely like to continue to chat about that one. Thanks for joining us, Jory. Leona Frank, would you look into Corey Richens? Now, Corey Richens, I think that's the case. I'm starting to get it confused here. The names confused. Corey Richens is the mom who is accused of murdering her husband and then writing the children's book about grief. I think that's the right case. I think that's an interesting case as well. I know that there are some other sort of cases that have come up out there that I think I would like to take a look at as well. So we'll keep digging around, and if I've got the wrong case, tell me. But I think Corey Richens that's that case. So, and I think that's a really interesting, odd case. Hi, Flashback. Do I expect Arizona charges against Melanie Pulaski? I think they're possible. Do I expect? I'd put it at 50-50. We know that the indictment against Lori for Brandon Boudreaux was only just unsealed. We don't know if there are any other indictments that have yet to be unsealed from that grand jury. And we don't know whether it's possible that charges could have been filed against her as well. So I know that there are a lot of folks who feel that there are a couple of people out there who should have been held accountable, and that Melanie Pawlowski is one of them. And but remember that law enforcement have to be able to create a connection. They have to be able to produce evidence to prove beyond a reasonable doubt that it was Melanie who tipped them off to where Brandon Boudreaux was living. Now, everything we've heard is that there were only a handful of people who knew where Brandon Boudreaux was living. He had just moved, and that Melanie was one of them because the court directed him to tell her, because he had the children, where he was living with the children. Of the people who we know of who knew them, Alex Cox is the only one who knew Melanie. That's what the word is out there in the interweb. But we don't know whether that's enough for the police to make that connection and be able to charge her with part of this conspiracy. I also think that the prosecution down in Arizona were holding off out of respect for the Idaho prosecution and waiting to see what it was that Melanie was going to do when she was called as a witness. We know that she went down in flames because she admitted that she had been watching the news coverage and she had watched Brandon Boudreaux's testimony on the stand, and that she did that because there's some sort of a custody dispute still going on over their children. So I don't know what we're going to see. It is possible that the prosecution is now saying, well, you didn't do the Idaho prosecution any favors, so now we're going to file. It could very well go to a grand jury. I think it's a 50-50 proposition at this point. And this is one of the things that we don't know what we don't know. $900 people here on Memorial Day weekend. What the heck are you folks doing? Those of you who know that I moved to Idaho to write the book about the Vallow Daybell case, and know that I moved into one of the communities just outside of Boise. And I live in a little neighborhood, and there are a lot of young families here. And I'm here to tell you that they are getting their toys out to go play this Memorial Day weekend. They're getting out their campers and their fifth wheels and their side-by-sides and their ATVs and their motorcycles. Everybody's very excited about the fact that the weather has finally improved here in Arizona, or in Idaho, and people are getting out and about. So this is the first big weekend of the summer season here. Hello, Michelle Morris. Do you think Kay and Larry will wind up helping Chad by their statement that Lori could have ended up killing Chad and moving on to number 6 or 7 if they hadn't been caught this time? Not really. I don't think so. I don't think that that's a thought that anybody hasn't had. I think lots of people have had that thought. If you subscribe to the idea that Lori had something to do with the death of Joe Ryan, either directly or indirectly, and then of course is involved in the death of Charles Vallow, then certainly I think you look at Chad and think, maybe the odds aren't that good. So, but I don't think that'll do Chad any good when it comes to court. Hi, Ashley Shannon. Can a lawyer drop a client mid-case if the client can't pay it? You bet. Every lawyer's contract says, I can fire you if you don't pay the bill. And most lawyers have a provision that says, if the bill gets to be X, we're done. So, but we don't know what the fee agreement is between John Pryor and Chad. We don't know whether John Pryor said, you give me your house and I will do the case, whatever it takes. We don't know. Lawyers take flat fees all the time and say, you know, in cases like this and in criminal cases, it's very typical for a lawyer to say, you're going to pay me X and I'm going to represent you. If it means your case goes to trial, it goes to trial. If it means it resolves before trial, then I still get to keep the fee. It's kind of the law of averages for lawyers, especially lawyers that do a lot of the more low level criminal work, especially like DUIs. So client comes to the lawyer and says, I got a DUI, it's my first, I want you to defend me. And the lawyer says, okay, I'll take a look at the case, but my flat fee to represent somebody in a DUI is $2,000 and or $3,000 or whatever. And whether I take your case to trial or whether you plead out, the fee is the same. So that may very well be what Chad said, what John Pryor said to Chad. You have paid me whatever he'd been paid to that point. You sign your house over and we'll call it good. A lawyer can make any kind of fee arrangement that they choose with their client. John Pryor could say, I'm going to represent you for free. That's a choice the lawyer gets to make. And the lawyer could have any number of reasons for doing that. So it isn't something that's knowable at this point. I hope someday we'll figure it out. Angel Baby. Question. Approximately how long does it take for the appellate court to decide an appeal is accepted or not once it's filed for bad Lori? So the appellate court, you file a notice of appeal. The appellate court then tells the lawyers what their briefing schedule will be. And then the appellate court will, in this case, the Supreme Court, will determine when that hearing will happen. Appeals courts are very complicated. So let me just drop back here because I feel like I've left out a couple of steps, which is why I seemed a little bit vacant there for a minute. So if a case is appealed to the appellate level court, so most states have a trial court, an appeals court, and a Supreme Court, okay? If the case goes to the appeals court cannot refuse a case. But if the case goes to the appeals court and the appellate level makes a decision and the person wants to appeal the appellate level to the Supreme Court can say, we're not going to hear that. Now, the only difference is, the only exception to that are death penalty cases. And death penalty cases go directly to the state Supreme Court. So in this case, because death penalty came off the table as to Lori, her case will have to go to the appeals court. The appeals court will have to decide whether or not they're going to, will have to render a decision. And then the Supreme Court is free to decide whether or not they're going to reconsider what the appeals court has done. Hopefully that made sense. So usually what happens is they file their notice of intent to take, or intent to appeal. And the next thing that happens is they have to get a written transcript by a certified transcriptionist created of the entire trial record. A 5.5-week trial is going to take months, if not a year, to get a transcript of. So nothing goes forward until that transcript is complete. Once the transcriptionist notifies the appellate court that the transcript is complete, then the court will tell each side how long they have to get their opening briefs in. Usually it's about 30 days. So the opening brief is the appellant, the defense in this case, would file their brief and list all of the things that they think that the court did wrong or errors that were made in the trial. And then the prosecution will have the opportunity to answer those. And then the appeals court will set a trial date, a hearing date. And both sides will be able to go in front of the appellate court, argue, and then there will be, and then the appeals court will make a decision. Now, the appeals court, it could be months after the hearing is held and oral arguments are heard that the court finally renders a decision. So in all, I suspect that you're not going to see anything, you're not going to see oral arguments for probably 2 years at the soonest. A lot of it's going to depend on when that transcript is done, but then you have to, it sometimes takes up to a year to get a date on the court's docket just to do oral arguments. So it's a very lengthy, time-consuming process, and it sure as heck is not going to be isn't going to happen soon. Raggedy Hobo. If Lori gets a new trial, is the death penalty still off the table? Yep. The appeals court could say that the trial court erred, made an error in taking it off the table to begin with. And I'm sure that the prosecution is going to be asking the court to find that. But if they were going to reinstate the death penalty, they would have to file a whole new indictment and notice of intent to take the death penalty. Hi, Christina. The death penalty is not an option in Arizona. In Idaho, conspiracy to commit any crime carries the same sentence as the underlying crime. So what that means is if the potential sentence for a robbery is 15 years and you conspire with somebody who's going to commit the robbery, it's still 15 years for the conspiracy. Likewise, if you conspire to murder someone and murder is a death penalty crime, then the conspiracy is also a death penalty crime. It's not that way in Arizona. So in Arizona, the maximum penalty for conspiracy to commit first-degree murder is life in prison with parole possible after 25 years. So that's a mandatory sentence because Arizona has determinate sentencing. So it's a mandatory sentence. The court can't say, oh, you're a nice person, or we think that you should get parole after 12 years. It's a mandatory sentence. So the maximum, the mandatory sentence, there isn't a minimum and a maximum the way there is in Idaho. It's a straight mandatory sentence. So the sentence, if she is convicted of conspiracy to to murder to murder Charles, the maximum sentence would be 25 years, life with parole after 25 years. It's the same sentence for Brandon Boudreaux. So she could end up with 2 life sentences and 2 25-year periods until parole. The question will be, if she gets convicted of both of those, whether they run consecutive or they run concurrent. That the judge does have some leeway on. So, do you believe Alex really died a natural death? I've got my tinfoil hat and my magic 8-ball hat. Thank you, Lori. Another good Lori. I have some real questions about it, but I think that he was such a believer. I think that there are a couple of really important things that came out in the trial, not the least of which was Summer's testimony that Alex had a traumatic brain injury at age 16 in a car accident, and that he had never been the same. I think we'd all speculated that there was something different about Alex, whether it was an injury or a birth condition, that he was different from the rest of the Cox kids. And it came out that, in fact, he had had this traumatic brain injury at age 16. And Summer's testimony that he always was somehow sort of emotionally and intellectually 16. And that makes a lot of sense, because I think that he was absolutely 100% all in on Chad and Lori. And I believe that if they had said to him, it is time for you to end your life so that you can go on to the celestial kingdom and prepare a place for us, he would have done it. And I think there is a real possibility that Alex took his own life. I'm not convinced that Lori and Chad murdered him, but I think they manipulated him into committing suicide. Hi, Lynn Petticord. I most certainly have started a draft for my book. I am deep into talking about the influence of the church, and deep into starting to synthesize all my summer reading. I held this up earlier, but if you weren't there, you weren't on yet, you won't have seen that this was my summer reading. And you're welcome, because I read it all so you didn't have to. Including a couple of Chad's books. There's a few more around here that aren't in that stack, another stack about that size. So I'm beginning to synthesize what I've learned out of those things and put it together with what I've learned in the trial about their beliefs. So that's where I'm at right now. I have FOIA requests out, and probably in the next week, I'm going to go back and start re-listening to the trial recordings again as I go through my notes and begin to put all of that into some sort of order as well. So it has been an interesting experience digging into all of that stuff. And I'm sure that there is a lot more. We know that there were 15,000 text messages, and that what we have seen so far is only a small percentage. I fully expect that the prosecutor's office in Fremont County and some of the other entities are going to drag their feet and try not to give me those things until Chad's trial is over, but we'll see. Hi, T Diva. If Lori is found guilty in Arizona, where will she serve her time? Arizona or Idaho? Probably both. I think that in general, The convictions go chronologically, so she would serve any sentence in Idaho first. If for some reason she were released in Idaho, let's say her conviction was overturned or there were some other reason why she was released, she would immediately go to Arizona and serve her sentence there. So, as I've said before, in these kind of cases, it is sort of the belt and suspenders. The prosecutor understands that if something goes amiss with the Idaho case, there's always the Arizona case as a backstop. There were a lot of people who said, why would you bother to continue to prosecute her now that she's been convicted in Idaho of the murders here? Isn't that the most serious thing you can be convicted of? And I say, absolutely, that is true. However, Charles Vallow deserves his cup of justice, just as all the other victims do. Brandon Boudreaux deserves his cup of justice. So even though we're piling on sentences that are she couldn't serve in 2 lifetimes, it's still important to assure that justice is served for all of the victims. And I think Kay made that point as well, saying, Charles was my brother. And yes, we wanted justice for JJ. He was a child. We wanted justice for Tylee. She was a child. And we wanted justice for Tammy as well. But we want justice for Charles as well. So I think she will be convicted, and I think she will have those hanging over her head. And should there come any time that her sentence in Idaho isn't served, she's released for some reason, I think Arizona's there as a backstop. Hey, Hazelnut, thank you. You are always so generous to our moderator. Always great discussions here. You're right. I don't know how many times I've heard from people, you really have the nicest people in your chat. All 912 of you on Memorial Day weekend, thank you. But we do have nice people in our chat. Michelle is able to handle the moderating because y'all are easy. You kind of keep things elevated. You keep things friendly and respectful, and I appreciate that. And I think a lot of it has to do with the fact that you come here to get educated and to learn something about the cases that you're following. And I think that folks who are here to learn something aren't here to just argue and snipe at one another. And so I appreciate that more than I can tell you. Hazelnut, thank you. You are always so generous to our channel. Venus Gal, why is it, if pertinent to a case, the other side can't find out how they pay their attorney? For instance, a child custody case or a divorce case where spousal claims no income for support, but then can afford an attorney. Oh, well, that's a little bit different calculus. So in a case where money or income is an issue, then I think it is reasonable to ask who's paying for the lawyer. So, in a divorce case, if you have one spouse who's saying, I don't have any income, I can't pay you child support, but oh, by the way, I got the most expensive lawyer in town, there's a misfire there. And it's certainly reasonable to ask for that information. Now, in most family law cases, there is mandatory financial disclosures that have to be made. So each side has to disclose their financial situation. has to disclose their bank accounts, their all of their financial records going back sometimes 3 to 5 years. And so all their income, all of their debts, and so usually it's possible to track that down. And certainly it is a question that you ask someone on the stand if you are having that kind of a conversation. Interesting that you don't have any income and you can't pay child support. However, you have paid for your lawyer, and how much an hour does your lawyer charge, and what was the retainer that you paid your lawyer? Those are all questions that are well within the scope of what is appropriate to be asked in that situation. So it is different than in a criminal case. Good question. I just saw a comment, Jory. I'm a little behind in the live. There's quilting too. There is quilting too. That's what these guys are back up here on the wall. I'm going to answer this one too. Let me just turn here so you can see lots of quilt squares up there on the wall. So catch up, Jory. NF Mom. Question, are they going to have to wait until after Chad's trial to bury the kids? I don't know. This is a decision that is purely up to the prosecution, and I don't know. I hope not. I hope that they will finally relent and release the bodies of the children and let them be buried. But I don't know. That is a decision that Lindsay Blake and Rob Wood are going to have to make. And I hope they make the right one. It's time. Hi, Chelsea J. The Woodcocks aren't next of kin to Tylee. The general presumption is that JJ and Tylee will be released to them to be laid to rest. Doesn't Tylee's bio family, i.e. Annie, have to consent? No, Tylee's next of kin will need to consent. And as far as I am concerned, I believe that is Colby. He is the most direct next of kin. My understanding, and you know, these kinds of situations are fluid. They're very emotional. They're very, my understanding is that the Woodcocks have offered for Tylee and JJ to be together. And I believe that Colby and the Cox family have all agreed. I don't know what Annie Cushing's position is, but I'm sure that she would be consulted. But ultimately, the immediate next of kin would be Colby. And I'm sure he would prefer that they stay together. What a spirited discussion we've had tonight. Haley here. Perhaps Arizona law enforcement should face a civil suit for lack of action Ray Charles, therefore being partially responsible for his death. So I don't think that is outside the realm of possibility, but the law varies from place to place on how, when you can sue the government. It is usually for negligence. And so they would have to prove that that law enforcement were negligent in the way that they handled Charles's requests for assistance and requests for the orders for Lori to be evaluated for her mental health. I think it's possible, and I suspect that Kay and Larry have looked into that possibility as well. I don't know where it goes, and in Arizona what the restrictions are on government suits. They have some time. So I don't know what the statute of limitations is, but they have some time yet. So I would I'm sure that it is something they have looked into and consulted lawyers on. Sue Komernicki? Sure, I'm butchering that. I'm sorry. Did the medical examiner in Idaho and Arizona ever release what drugs were tested in all the deaths? So I believe that the toxicology report generally reports what drugs were tested for. Not every drug is tested for. They start with the most common and go to the more rare. And every drug has to be tested for individually. So sometimes they run out of material to test. Sometimes they just run out of the probability of what a substance might be. So, for example, in JJ's toxicology report, there was a very minute trace amount of a drug that is known as a date rape drug. It was tested from the liver, and it is also known that that particular substance can be generated by decomposition. So we know that they were testing for those sorts of things that were probably more obscure and less likely than some of the other possibilities. But when it comes down to exotic poisons or rare kinds of substances, they probably did not test for them. But the toxicology report, which is usually an addendum to the autopsy report, would list every substance they tested for and what the result was. Barty B. Was there anything else that Charles could have done to get help for Lori in Arizona? Should he have talked to a detective after the uniformed officers? Are there other resources? This is a great question. I think that given the resources that Charles knew of, he exhausted everything he could do. I do think that, he started out by going to law enforcement and saying, help me, she needs a mental health evaluation. She went and had the mental health evaluation. Those kind of evaluations are, truthfully, they are very cursory. And, if you're not drooling and you're not hurting yourself, then it's likely they're going to let you go. So that probably wasn't the best avenue for Charles to get help in this situation. I think that perhaps his best alternative would have been to take JJ with him and not return him to Lori. But the decision was made to return him to Lori. Hindsight's 2020. We don't know what was going on in the dynamics of that family. Maybe JJ was struggling because he was away from his mama. Maybe, and from Tylee. We don't know what the whole dynamics were. So it's hard to really have hindsight. He tried to do a family intervention for her and it got him killed. So I don't know that there was a tremendous amount more he could have done. I think he could have filed for full custody of JJ. I think he could have asked for an emergency order, an emergency custody order for JJ if he felt like JJ was at risk being with Lori. But she was very chameleon-like, which is not unusual, as I am learning in all of my reading, in when it comes to sociopaths. Sociopaths tend to blend in. They do not present as blatantly mentally ill. They don't. So they're able to blend in much more with what's going on in their lives. So TN Girl 179. I thought Boyce allowed the indictment to be amended because the charges were numbered correctly throughout except for one place, a typo. So I thought, no big deal. Are you saying it was more than a typo? No, I'm not saying it was more than a typo. But what I am saying is that the language of the indictment read differently than the number it was purported to be. So the citation, the number of the statute didn't match what the words said down below. I don't know if that was a typo or whether that was a mistake or a cut and paste mistake, or, I mean, I don't know. But it did, the defense is correct that it did change what Lori was charged with. Because what they changed, they changed it from, I'm going to look it back up here again. Because the language changed from intent to deprive, that theft with intent to deprive the owner of the property, to theft with intent to deceive the owner of the property. And that is slightly different. And it is a slightly different proof issue. So I think that what it meant was that it changed the language, that the defense was on notice that the defendant was charged with. So a typo in the indictment can be fatal. A typo in the indictment can cause problems that can completely torpedo the case. The indictment is that critical to the case. Always wondered, did anyone else notice that the female officer on scene with Charles was also the first officer on the scene for Brandon's attempted murder? Her voice on body cam is extremely distinct. You know, I didn't notice that. I didn't. I did notice that when Charles is talking to one of the officers, he asks them, and I think it's the female officer, "Are you LDS?" And one of them said yes. And then he went on to talk about what Lori had been talking about, the crazy things she'd been saying about the church. Hi, Denise. Did you see that the prosecution in Kohberger case demanded of the defendant notice of defense of alibi? The prosecution asked for the notice of alibi in a request for discovery filed on May 23rd. I did see that, and I did think that that was interesting. I don't want to conflate two things, because in the Pennsylvania case, law enforcement said Kohberger was not involved and that he had a solid alibi. So I don't want to conflate that with the Idaho case. It is very typical If you recall, Lori Vallow's case, they didn't file that notice of alibi until far late into the trial. One of the complaints the prosecution had was that it wasn't timely, that they have a fixed amount of time to file that. I believe that the prosecution is now saying, if you're going to file your notice of alibi, we're on record as saying we're not going to fudge that date the way they did in Vallow, that you're going to have to file your alibi notice within the prescribed time, which is probably that May 23rd date. I don't know if it's 30 days or 60 days, but it's a fixed amount of time that they have to file the alibi. So I think that's probably why the prosecution demanded the alibi. Question: do you think Mel P will be charged in Brandon's case? Don't know. I think it's about 50-50. Because we just don't know what's going on behind the scenes. We don't know whether there was any sort of agreement about her testifying in the Idaho case. We don't know what impact her not testifying in the Idaho case might have had. So I think it's really an unknown. And I do think that we also, what we don't know is if law enforcement can actually prove that she knew and that she told Alex Cox, Brandon's new address. We know Alex Googled it. Now, how did he get it? If Melanie is the only person he knows who knows Brandon's address, then that's circumstantial evidence. But I don't think we know yet whether that's going to happen. We also don't know whether there are any other sealed indictments that came out of that same grand jury, because Brandon's indictment came out of the grand jury at the same time Charles Vallow's did. It was just sealed. So we didn't know about it until just recently. So, but that's a good question. I mean, we just don't know. And that's, I know that there are a lot of people who would like to see Melanie held accountable, but the answer is don't know yet. But we will. We'll find out. I noticed that Michelle just put a note up about getting my newsletter. I have to tell you that I have been pretty remiss in putting out newsletters recently because of all the writing I'm doing. So it's hard to sit down and write a newsletter when we're working all day on writing book chapters. But I promise we will get a newsletter out shortly. Janelle Murphy, do you think that they let Mel P off the hook testifying in Idaho because of the Brandon case coming up? I don't know. I think that it's more likely that the prosecution felt that they could get what they needed out of Ian, that they were pretty confident that Ian had not been watching news coverage and had not been listening to the testimony. I think they felt they could get what they needed out of Ian, and it was a battle they were just not ready to fight. You know, I mean, when you are in a long trial like that and you are managing, I mean, you're keeping all those balls in the air. You are managing this massive amount of data and witnesses and all these moving parts that are going on. The last thing you want to do is take on yet another fight. And so I think they just decided to pick their battles and decided that it wasn't imperative that they get her testimony in. They could get what they needed in through Ian, which I think they did. And so I just think they decided that it was an unnecessary battle and they weren't prepared to fight it. They let it go, sent her home, and they're going to let Arizona deal with her. That's a good question. So we're coming up on the end of our 2 hours. So let's take a few more last questions. If for some reason we've had a pretty easy night tonight, I didn't talk for too long ahead of it. But if for some reason you didn't get your question answered, please put it in the comments below or email it to me if you don't like making your a public question, and we'll try and get them answered that way. TXL Texas Lady. Okay, that's a cute handle. Since the defense didn't correct the typo in the indictment for nearly the entire trial, wouldn't the appeals court dismiss that effort? Well, it's not the responsibility of the defense to correct the typo. It's the responsibility of the prosecution to correctly draft the indictment so that it puts the defense on notice of what the defendant is charged with. It is not the defense's job. The defense did, both defense attorneys asked for a bill of particulars. And the reason they did that was that they wanted the prosecution to say exactly what it was that they, exactly how their clients had violated those laws. And I think they were hoping that if they could get the prosecution to take a hard look at their indictment, they would realize that they had made an error. But it is not the responsibility of the defense to correct the typo. So, good questions. I'm running out of water here for my scratchy throat. Hi, Denicia Rose. Am I planning on writing a second book? There are so many additional trials coming up, and I think you have a series we're all interested in reading. I am absolutely going to write until I drop behind my keyboard. So yes, I'll be writing other books. I'm not sure what the next book's going to be, but it probably will be true crime, and it likely will continue to build on the things, the platform that I've already built, the audience that I have already built. So yeah, the next book, the next project is probably on the horizon. I need to get this one in the can, as they say, in the movie world. I need to, my publisher and editor are hoping to have this by the end of the year, and I am keeping my fingers crossed that that is going to happen. I have a couple of family obligations that are going to happen, and I'm going to go to CrimeCon. So those are going to take a couple of little chunks of time. But other than that, absolutely, I'm going to be working on it. And I'm going to get that one out by the end of the year, I hope. And then we'll move on to the next project. I'd love to hear from you if you have things that you'd like me to consider. I think the Kohberger case is a very interesting case and certainly on my radar at this point. Thanks for asking. Writing is a real joy to me, and so I'll be doing it for as long as I can. Oh, thank you, Michelle. Please, today is going to be our last Saturday live. We moved to Saturdays because of the trial, but now that the trial is finished, we are going to be moving our lives back to Wednesday. You might recall that we did Wednesday, Friday for a while, but I think we're going to just stick on Wednesdays. That means that we don't conflict with a lot of other folks, and it means that we can move forward talking about a variety of cases. So starting Wednesday, we're going to be back to our Wednesday format where we are going to be talking about whatever the cases are that are in the news. I promise that I will get a little more up to date on the Petito case so that I can give you a better read on that one. And we'll move forward with some of the others. I know we haven't talked about Delphi in a while, so we need to dip into that one. And there are several others that are of interest. I have been watching that Travis, see, now I've lost it again. a mind like a sieve. Travis Rudolph. He was an NFL football player who was murdered by his girlfriend's brother, apparently. And that's been kind of interesting. There was a lot of really interesting sparring going on between the girlfriend and defense counsel in that case. It got a little fiery at times. So stick with us. We'll be back on Wednesday. And oh, thank you, Michelle. I do want to, because I'm a veteran. My husband's a veteran. My dad was a veteran. I do want to point out, please, everybody, have a safe Memorial Day weekend. Please remember that Memorial Day is to remember those who died in the line of duty, to remember our service members who gave the ultimate sacrifice. And Veterans Day is for remembering and supporting all of us who served. So have a great and safe Memorial Day weekend. Please take a minute and be grateful for for those who have fought and died for our country. I'm going to say good night and thank you all for being here. Thanks once again for over 900 people on a holiday weekend. And I will talk with you all on Wednesday. We'll see you then.